All right, good evening. Thank you for joining another session of the Simplified class. So we'll be having constitutional law tutorials today, and our tutor for today is Selassie Atamuji. Can just call him Selassie. So that much I do. Selassie, please take over.
Good evening. As she said, my name is Lati Kwame Atamuji. You can call me Atamuji, not Selassie, because the Selassie is quite generic. Yeah. And then for today, I'll take you to, I think, coup d'etats. That's the constitutional law. And then I don't know if you guys have a PKO notes for constitutional law, because that's what I'll be referring to most of the time today during our session. So then, without wasting too much time, I would want to delve in quickly. So, coup d'etats are like often illegal seizures of powers, which are like most of the times done by military forces or like groups within a country. And then if you have to go into Ghana's history, you realize that most of the times it was actually done by military forces. So to give you a little historical context, the first coup d'etat in Ghana was actually happened in 1996, 1966. Sorry, 1966. I'm so sorry about that. And then it occurred on February 24th when the National Liberation Council overthrew the government of Kwame Nkrumah. And then they tried to justify this coup on the grounds of corruption and mismanagement. And then there was one in 1972 which was led by Colonel Ignatius Kutu Champong, who replaced the NLC government. And then in 1981, when Jerry John Rawlings took power through a coup, and I think it was through him that democratic governance in Ghana was actually birthed. So you find that in the 1990 constitutions, I think in the first chapter, you realize that coup d'etats have actually been banned in the sense that if an individual tries to abrogate the constitution or tries to do anything in the sense that it wants to abrogate it or like nullify it, realize the penalty is that this is actually a deterrent to people to try to take us back into those times. And then if you look at like case law, you realize that Salah, an attorney general, actually is like what's the name? A landmark case when it comes to that. And then there is Shalabi versus Attorney General. Shalabi versus Attorney General. Well, so in Shalabi versus, you realize that the case highlighted the legal challenges that was posed by the actions of a military regime, and the Supreme Court examined the legitimacy of actions taken. I think it was basically about a person contesting the fact that his appointment by the previous government was revoked as a result of the proclamation by the NLC people. And I think courts, um, the courts, give me a second. So the courts, please give me a second, I'll be with you soon. So I think the court is not actually, they saw, I would have to clarify, right? But it was between one of theories. I think it was in Phyllis's theory of continuity, where Phyllis actually argued that Phyllis argued that um, a Bruno So Phineas actually didn't agree with Kelson's theory of the Grunum in the sense that once a legal order has been abrogated, a new one, no, once a legal order has been abrogated, right, a new one actually has to come into effect. So the previous one doesn't actually have any, how do I say, legal authority or like a new one that they are able to. So I think Hans Kelsen was actually talking about, because I'm having network issues, so let me try and reconnect. Please, I'm so sorry about the network issues. But then when we look at so you let me just take you through Kelson's this thing first before I try and relate it to the Salah versus Attorney General's case. So then you realize that Kelson was arguing that every country has a GRU norm, and a GRU norm is a basic norm from which all other laws will derive their validity from. So we can talk about the 1992 Constitution actually deriving its validity from Ignatius's military proclamation. So that is what Kelson. So it will be fair to say that Ghana actually employs um, the theory of Hans Kelsen in the sense that they believe that every rule of law is actually GRU. So we can say that the GRU for all constitutions in Ghana actually started from uh, Nkrumah's constitution. So like that was actually the first constitution that was. So it could be said to be it could said to be the British people in 1957. Yeah. So we can say that we could derive our this 1990 constitution. The GRU could be from that time, the 1957. And then Finnis actually begs to differ in the sense that for a revolution to actually occur and result in change in the legal order, certain salient rules must be affected. He says the rules of succession to office, the rules of competence, and the rules of succession of rules, which includes all rules which constitute the amendment and suspension of new rules, must be affected. So Finnis is actually of the opinion that for there to be a successful revolution in a country, all these three categories actually have to be affected. So coming to that, so Uriah and Sarah versus Attorney General, there's an argument as to whether the proclamation by the National Liberation Movement amounted to the new basic norm, thereby putting aside the 1996 Constitution, 1966 Constitution, sorry. So that is to say that the initial basic norm, which was the 1960 Constitution, was abolished, and due to the proclamation by the National Liberation Council was a new GRU norm, as Kelsen would have put it. So the argument arose from the plaintiff asking for a declaration that his office fell outside of the offices stipulated in Section 9 of the transitional provisions in the 1969 Constitution. And as such, the decree which came about asking about all public officers to vacate their offices in 6 months, 6 months' time upon not being reappointed by the government. So the plaintiff argued that his office was actually not created by the instrument of the military declaration. So he realized that in Justice Archer's judgment, he decided that although the argument from Kelson's point of view was very sound, it was not enough to describe whether the plaintiff's office fell among the categories of office by the proclamation. He said that the theory could not also be used by the people of Ghana, as stated in their preamble, that their basic norm was traced from the Almighty God, which they had, which they had their constitution, and their legal order was their constitution, which had a special element of predictability, which the proclamation did not have. So the NLC proclamation did not make the theory from Kelsen applicable as at the time. So you realize that in terms of as Attorney General, the court actually didn't didn't go in tune with Kelsen's, because at the time they claimed that it was a foreign theory, and that the people of Ghana actually founded their grown in the Almighty God and could not see it was like the previous constitution prior to the military, what's the name, proclamation. So then we could move on to so we could move on to so for okay, yeah. So we could move on to the legitimacy of military regimes. So while the coup is actually very illegal, these military regimes actually come and justify the authority and notions through, I don't know, through like their proclamation. Because at the time where you overthrow a government, it means you're overthrowing the whole rule of law. So it means even the constitution being the supreme law of Ghana for us is being overthrown and it's being abrogated. So once it's abrogated, what actually are you doing the people? Like the question is, based on what laws are you actually governing the country? So you realize that most of the time, once they do it, they actually put out decrees or proclamations until a new constitution is actually made or something. So I think a very, very important aspect of this discussion would be that we actually dissect the Phyllis's and the Hans Kelsen's theories of the coup d'etat, because I think you may or would be examined on it. So I think we've already spoken about Phyllis's in the sense that three aspects of the rule of law actually have to be overthrown. So then the first one is the rule of the succession to office. The second one is the rule of incompetence, and the third one, rule of succession to rules. So Kelsen's own theory is that every country has a rule law, and that for any legal order to be established after that rule law, it has to take its validity from the previous ones. So it means there has to be an establishing one. So once there is no what's the name, rule norm or any previous anything that any sorry, once they cannot derive its validity from any rule norm, it could be said to be as what's the name, null and void. So now I think Naki shared some questions with me for said there were tutorial questions. So I would like for us to go through it. So for the first question was first question was what's the status of constitutional rights post coups? What's legal status of rights and institutions created by a constitution hold once the constitution is overthrown by coup d'etat? I would want this to be a discussion, like a session, so like I can see where you people are going and where to, so that if I have to come in to help, I would. So I would want us all of us to actually unmute our mics so that we can discuss it. Hello.
Hi.
Yeah. So, so on the first question, right? Um, yeah, on the first question, what do you think about the legal status? What legal status do rights and institutions have
Stella, did
once?
you need me?
Yeah, I wanted it to be what's the name? An informative session. Like right now, I'm on the tutorial questions, right? So then I wanted to see what the ideas or where like what they are. I don't know how to say it. You get what I'm trying to say? What ideas they have about it. So then I was just getting you to tell them to come and put their minds up so that we discuss it.
The tutorial questions.
Yeah,
Then let me send it to the group so that they can follow.
yeah.
Okay, sure.
So Naki, once you are done sending it to the group, please let me know.
Okay.
Yeah, thank you.
Selassie, I just did.
Okay, okay, that's fine. So then the first question is, what legal status do rights and institutions created by constitution hold once the constitution is overthrown by coup d'etat? Please, you guys have any idea? You can unmute your mic and actually talk. I want to hear what you guys have to say. Mr. Samuel Ofosu, do you have any idea?
Just going through the questions so that I come up with something.
Okay. So please, as and when you're done, please just let me know. I'm on standby. Because I want this to be an informative session so that like we discuss it then all these things.
Okay, let me try something.
Okay. So the first question is what's rights and what's legal status do rights and institutions created by constitution hold once the constitution is overthrown by equity?
Okay. I think institutions are created out of an established constitution.
Yes, that's correct.
Yes. And once that constitution is overthrown, the rights and obligations of these institutions will need to come into the new order that has taken place. The old order that has been overthrown may not actually apply.
Yeah, actually, you see, that can be seen in Salah versus Attorney General when you realize that they tried to, what's the name? They tried to take the plaintiff out of office. And then he sent it, and then there was an argument as to whether Hans Kelsen's, what's the name, good knock theory can actually be incorporated in the Ghanaian court at the time. Do you get it?
Yes.
Yeah, so it means that for the legal status of these institutions, it will have to actually depend on the proclamation or any rule of law that these military regimes actually bring out. So if it comes to the point where it says that so and so and so this office is what's the name? It's not recognized by this. You by virtue of that proclamation, they actually lose your office. Yes. Then moving on to the second question 1B says that consider the historical context of coups in Ghana and other African countries. Do the institutions and rights created by the Constitution cease to exist or merely adapt to the new regime? Please, does any other person on the call aside Mr. Samuel Fosu? Please, Sam, what do you think about it? Sam, Mr. Sam, what do you think about it? Okay, Miss or Mrs. Clarissa and Kitia, please, what do you think about it? Okay, then it looks like I'll have to proceed.
I think it depends on the approach of the new regime.
Okay, in what sense?
Sorry?
In what sense?
If the people are in line with what the new constitution is bringing on board and they are aligned, then we can say that that new constitution is going to be enforced or it's be successful. But if they do not align, then the new regime be abrogated. I don't know. That's what I think.
Okay, yeah, it's actually right. So it depends on what actually the new regime actually puts out. Whether if those officers are actually not in that military proclamation, I think they actually cease to exist. Or if there are provisions made for them to actually say this and okay, so maybe if there are provisions that are actually made for them to adapt, they would adapt. So it's actually based on what the proclamation is actually about. Okay. So then moving on to the role of the GUNOM in revolutionary context. So drawing on Kelson's theory of the GUNOM, what happens to the legal system when a coup or revolution takes place? So then moving back to Hans Kelson's discussion, it says that so Kelson is of the view that every country has a GUNOM, and that the GUNOM is the basic norm from which all other laws derive their validity from. In his view, right, taking away the GUNOM collapses the existing order. Kelson assents that in every revolution there's a change in the legal order. That is, the legal order is completely nullified and is replaced by a new legal order, a way not prescribed by the first. In Kelson's book, The General Theory of Law and State, he believes that the legal structure of a country to be in a form of an inverted collapsible pyramid of which the GUNOM is at the base, serving as a source of validity or rock of all laws. When the GUNOM is taken away or destroyed, the inverted pyramid actually collapses for a lack of support. So all other laws cease to exist and paves way to a new legal order. The spectacles of Kelson, the legal effect of a coup d'etat is to remove the rock bottom of the collapsible inverted pyramid, and that will send the metaphysical whole structure crashing down. Does anyone have a question? I heard a voice, so that's why. So from what Kelson says, every country has a GUNOM, right? So it's like in Ghana, we can say that all our laws that we find right now could actually trace its validity up to the 1957 Constitution. The sense that it was the first one, right? And if you're able to read the Constitution that was used in deciding the case of the former Attorney General, and you compare it to this 1990 Constitution, you realize that we have similar provisions and everything. So it is fair enough to actually conclude that some of the 1990 Constitution could actually derive its validity from the Constitution that was. I've forgotten the year in which that Constitution was actually was created. Like it's fair to say that the Constitution was actually derived from it. So back to the question. The question is drawing. So what happens to the legal system when a coup or revolution actually takes place? So if from what I was saying earlier, where Kelson was actually saying that so when there's a what's the name? When there's a revolution, right? There's a change in the legal order. So the change in the legal order to be said to be the fact that it is completely nullified and is replaced by a new legal order. But not in the sense that every single bit the previous legal order was actually taken away and nullified. No. The only reason why the previous this of the legal order was actually taken away is because when the military does it, it means that they have abrogated the constitution. Right? So they now have to actually bring out whatever laws and rules they want to use to govern them, because you cannot govern a select group of people, a set of people, without actually any laws and any laws that are written and codified, like in the country of Ghana, where you actually use a system of like a written constitution. So the legal order is not what's the name? Yeah, so the legal order is actually really taken away, and then a new one comes into play. That's going to say it's erased entirely. So moving on to 2B, using case laws such as Salah versus Attorney General and Shalabi versus Attorney General, we have to discuss the change of the fundamental legal order and its consequence. Okay, so in answering that, so you realize that these cases actually illustrate the impact on legal norms and rights. So in Salah, the court actually examined the legitimacy of the military regime's actions and whether they could be reconciled with the constitutional principles. So the outcome of these cases actually suggests that the judiciary actually may actually struggle with reconciling revolutionary changes with establishing. So if you look at the court's reasoning in Salah, right, the two justices I was saying that the court was actually saying that it did not recognize the Hans Kelson's theory of coup d'etats in the sense that it was foreign to the Ghanaian law at the time. And his basis for saying that he was relating it to the preamble. He said that the preamble stated that the people of Ghana actually was in the preamble, it was stated that the laws actually derive from the Almighty God. So that could be said to be the preamble of the Constitution and not what Hans Kelson was saying. So then he said so you realize that the proclamation of the NLC actually did not make the theory from Kelson applicable. So the court in a majority decision decided that the coup did not destroy the legal order before, but just changed parts of it. So can someone take me to Shalabi versus Attorney General? Anyone at all? Please, Mr. Samuel Fusu. Look at today, there's me and you. I don't know.
The
Are you familiar with Shalabi?
Little. I think it is about citizens' issue. Shalabi was a Lebanese that was born in Ghana.
Okay.
And around, I think the 69 Constitution declared that anybody that was born before, I think 57 or so, I don't remember it fully, but it was centered around a citizen issue. His citizenship had to change, and then a new regime came and also reversed that decision, and his citizenship has to change again, and all that. That is what I make up of the issue.
Okay, so okay, thank you very much. So So I think this case was during Jerry John Rawlings' time, where Abubakar Shalabi was detained under the PNDC laws. So he was arguing that the laws under which he was detained, right, were unconstitutional. Yeah. So he sought to challenge the legality of his detention and to affirm the protection of fundamental human rights guaranteed by the 1992 Constitution.
Okay.
Yeah. So you realize that some of the key questions that were actually raised there, whether Shalabi's detention was lawful under the PNDC laws or not, and that these laws actually violate the constitutional guarantees of personal liberty and due process. And then
Okay.
I'm saying this of him. And then what role did the judiciary play in actually upholding the constitutions right during this military listing? So you realize that in the court's reasoning, right, there was the constitutionality of the detention. In the sense that the Supreme Court actually examined the provisions of the PNDCL and actually found them inconsistent with the constitutional protections afforded to the individuals. That was one of the, and the judicial authority was at the court actually accepted its role in the sense that this time around, actually, well, if you realize in these military regimes, like the leaders of these military regimes actually put their people in place to try and manipulate almost everything that actually, so almost every arm of government. I'm not specific, but yeah. So you realize that in the judicial authority, right, the court actually this time around actually came to defend, became a guardian of the constitution, and then actually brought out, affirmed that the judiciary has the authority to actually review actions taken by the executive, even in a military context. And then in one of the rulings actually spoke about how fundamental human rights are not contingent on the political climate. So the court maintained the state's responsibility to uphold these rights, if you realize. Okay. So moving on to the yes.
Please, can you share the case with us? Because it looks like what I also saw is similar to what Samuel saw. So the brief he was giving you wasn't right, actually. So if you can share this with us, we'll be grateful. Thank you.
Yes. I'll share documents with Naki after this session so that people can have access. Yeah.
Okay, thank you.
You're welcome. So then moving on to the said review the case of Salah versus Attorney General and discuss the court's reasoning on the legality of actions taken by a regime that came into power. So Clarissa, please can you help us on that?
Nancy, please, I'm reading a minute.
Okay, no problem.
Please, which question? Sorry. 2C.
It's 2C. 2C. Clarissa, please, have you been able to read it?
I read it, Sebastian.
You can just share your thoughts on what, like, you can just share what you think about it or how, yeah.
Okay, so I actually do not recall the case. Um,
You do not, the Salavis Attorney General, right?
was it the one that the government changed power and he was laid off?
Yeah, that one.
Oh, okay.
So you have like, do you have any like, you don't have any idea about the case at all?
I think they use the Grundnorm, like you were saying, and then the court said that the Grundnorm was actually given by God based on the preamble of the 1992 Constitution.
Yes.
Um,
So
mhm,
so did you think that
mhm.
the NLC proclamation at the time actually took its inspiration from the Kelsey's theory?
Yes,
You think so?
yes, because the per Kelton's theory,
Uh-huh.
once a new regime comes, or once there's a coup, the entire uh, norm ceases to exist and a new one comes into play. So all that the previous green norms brought, it sees that it's abrogated, it ends. So then a new regime starts entirely.
So
So
in
that's
this
how
sense,
I understand it.
so you are saying that, okay, I see. But then if you realize in Justice Archer
Mhm.
judgment, he spoke about how the people, so he was talking about how in the preamble, the people, in the preamble, he said that in the name of the Almighty God. So Justice Archer was trying to say that the Bruno was actually derived from God.
Yes.
So you still think that the proclamation actually made the Kelsey's theory applicable? But if that's the case, then it did not make it applicable.
So per the judges or per the judgment, the
Yes.
reason that the blue norm was not given by God, or the our 1992 Constitution was explained using the preamble. So meaning that it wasn't legal. The legality was questioned.
Yeah.
Yes.
So it means that in Salabas Attorney General, they did not agree with the what's the name?
Yes, please.
Yeah, okay. Thank you very much. So let me call another person. So Osam, please can you help us with the expert in Salifa case? Mr. Sam or Mr. John or Miss or Mrs. Minnie. Could you help us with the Salifa case? Okay, so if no one is speaking, then let me touch on it. So just give me a second.
Selassie, are you there?
I'm so sorry. I have been talking. Oh, this is okay. So I was talking about the Salifa case. I'm so sorry. So in the Salifa case, a boy went to Guinea to further his education by his father. So he ran away from his guardian at the time for alleged maltreatment. So he went to the Ghana High Commissioner to help him get back to Ghana. So upon touching down, he was arrested and sent to prison. So his father actually went to court and submitted an application for habeas corpus. Habeas corpus. We all know what habeas corpus is, right? It's to, like, I don't know how to say it, to release the body or to show the body or like give evidence that a person is actually there. Yeah, to bring the body. Okay. So 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 yeah. But then the director of prisons actually sent something or some sort of exhibit A without any numbering, without any signature of the chairman of the National Liberation Council, and actually wasn't how do I say it wasn't gazetted as it should have been according to the proclamation by the NLC. So I think Justice Ankechi actually ordered for the release of the boy because the decree was actually invalid according to the NLC's laws, right? Because it wasn't numbered, it wasn't published, it wasn't gazetted. So you realize that the guy was released. But in the second Salifa case, he was arrested. He was arrested, what's his name, and detained for subversion under another unnumbered and unpublished National Liberation Council decree. So Salifa's in the second, I'm talking about the second case here. So in the first case, he was actually released. He was asked to be released by Justice Antechi because he was actually released because the exhibit A was neither numbered nor published in the Gazette, as it was said by the NLC's laws. So when he was arrested again in the Salifa case, his father filed another application for a writ of habeas corpus for the immediate release of his son under the grounds that the arrest without the warrant was unlawful, and further that the subsequent unnumbered and published decree was also invalid. So it was held that the NLC had so many powers in the sense that even though it proclaimed procedural limitations in this making of decrees, it also gave themselves the power to actually repeal and amend laws or make laws. So also a decree could be in effect even though it wasn't known to the public because it was not published in the Gazette. So in interpreting an act of parliament or a decree, and an act of decree should be read as a whole. So the cumulative effect of paragraphs 3, 6, and 7 of the declaration was that a decree could come into force and be uprooted or amnested, even though it had not been published in the Gazette. So you see, that is the thing about coup d'etats, and that is what I think the framers of our constitution were trying to prevent, in the sense that you can make a law there and say that yeah, it has to be seen as law. Because even though it was not said in the decree or published in it, what's the name? It could come into force and can be operated upon. So you realize that I'm coming. Give me a second. So going back to the question, it says that in Republic versus Director of Prisons, ex parte Salifa, how did the court deal with the detention power exercised by a military government? What implication does this have on the protection of individual rights at that? So you say that how did the court deal with the detention powers? So the court dealt with it on the laws that the NLC gave it, right? So first, when the court dealt with it on the basis of the laws the NLC had said, in the sense that any was in a law or act or decree has to actually been numbered or published or gazetted. So the court said it was invalid in the sense that it wasn't unnumbered or gazetted or published. And then you realize in the second case, the court came back the courts had to come back and say it in the sense that the NLC had actually given themselves the power to repeal or amend any laws that they had this thing. So they were saying that for the fact that it hadn't been gazetted or it has been unnumbered or what's the name, unpublished, gazetted or unnumbered and unpublished. What did he say? Let me read it again. It says that the NLC gave itself the power to amend, repeal, or make laws. Also, a decree could be in effect even though it was not known to the public. So you realize that this decision came then as the boy was being released. It's like a proclamation by the president at the time of the NLC said that the boy should be arrested, and they were saying that a decree could come into force and be repeated or amnested, even though it had not been published in the Gazette. And the word issue appearing in paragraph 3.1 of the proclamation, which in the context of present circumstances appeared to mean the operation of the decree, even though it was unpublished. So a decree could come into force in some other way or mode of publication, or even on some other day than by publication in the Gazette. That's a retrospective or prospective that could be put in the decree. So you see, in this case, they are trying to say laws could actually work in a retrospective manner, which shouldn't be so. So here in the case, to answer the question, it says that what implications did this have on the protection of individual rights? So I think people could not actually really exercise their individual rights in the sense that if a law under this thing, they could say that there's this law under this regime where it has not been published or it has not been gazetted, and then by virtue of the fact that they have said it has to come into effect. Did you get it? Please, are we following? Hello. Please, are we following?
Yes, please.
Okay. So, moving on to the third question. It said, if a coup d'etat is inherently illegal, what then justifies the authority that military regimes wield over a nation? It is merely a practical necessity, or is it merely a practical necessity, or is there some philosophical or legal justification that grants this regime legitimacy? So, to answer this question, I would say the justification. So, while a coup is actually very illegal, I said it earlier that regimes actually justify their actions through the notions of national stability and security. So the reason why we had some coups in Ghana was because whereas in Nkrumah's own, they said it was mismanagement of the economy and whatnot. So it was whatnot. So they actually so to answer what actually justifies the authority. So what actually justifies that the military will say that in their duty to actually protect the nation. Because obviously, if there is economic hardship, realize that civilians actually tend to become rebellious in the sense that they become frustrated and do not know what to do, and they tend to resort to unlawful means in trying to get answers from their people they put into power, right? So the military is saying that by virtue of the fact that the security of the nation has actually been vested in, and they've taken it upon themselves to actually go and try and abrogate or overthrow a government, but the fact that they are not managing the economy well, and that if it's not done, it could be anarchy, and then it could lead a country into a whole chaos. Please, you get it. So then, coming to the question, is it merely a practical necessity, or there's some philosophical or legal justification that grants these regimes wasn't it? So I think about that. So you realize that Is there a philosophical justification? I'm not too sure about that. So let's move on to that. Is there a question?
I think there was a hint. The Professor Kumados forgive us our trespasses.
Kumado's article.
I think
don't have access to that.
he shared it, but I'm using my phone, so I can't share. I'll see if I can switch. But I was talking about indemnity clauses.
Oh, in the 1990.
Exactly.
Okay, then. Okay, so you see, there is indemnity clauses in the Constitution, which offer legal protection to like military leaders from prosecutions for actions taken during their regimes. So you realize that if legal protection wasn't actually offered to the military leaders from their prosecution, I think Rollins shouldn't have been a democratic leader of Ghana. Do you get it? So it's further actually complicating the issues of accountability and legitimacy in the sense that the killing of people by Rollins or the acts of the soldiers during those times where Rollins was actually the military leader. The question is, even though there's an indemnity clause that actually offers protection to the military leaders, where is the principle of accountability and legitimacy when it comes to that? Are we following? So I don't know what the framers of the Constitution were trying to do here, but yeah, I mean, the Constitution has its place. So then we go to 4, continuity of obligations during regime changes. How does the coup d'etat affect the obligations of a state towards other nations? The treaties and international obligations remain valid, or are they subject to change based on the new regime's policies? Okay, so to answer that, so coup d'etat may actually impact a state's obligation towards other nations. So treaties and international obligations would actually remain valid, but they may actually be subject to renegotiation based on the regime's policies. Do you get it? So actually, I feel like the international treaties and obligations will actually remain into effect. Because right now, looking at President Traore, I think he's a factor leader of. I've forgotten the country, but I think it's Burkina Faso. You realize that he still has relations with other other countries, and some treaties are actually been to full effect. We can talk about the UN human rights, the UN human rights declaration, right? It's still in full effect in this thing. In the sense that universal and actually fundamental human rights are still being enjoyed by the citizens of Burkina Faso, and they are not being infringed upon in any way. Okay. So here we come down to the question 4B. It says that analyze in relation to both local and comparative examples, such as the transition from the NLC to civilian rules. So analyze in relation to both local and comparative. So I would say that the transition from the NLC to civilian rule in Ghana actually illustrates the complexities of maintaining international relations amidst regime change, with shifts in foreign policy reflecting the new government's priorities. So actually, there's a lot of complexities in the sense that if you have a leader that actually doesn't, so you know how we have socialists and then we have capitalists. So if you have a leader, that was a socialist that was on board before a leader that actually is a capitalist, you realize that there will be a change in some policies regarding that, regarding this, yeah, there'll be a change in policies regarding their two political theories, where their political ideologies. Yes, realize that there will be a change in maybe some of the treaties that come into effect. So yeah, basically. So let's go on to the fourth question. I may have to run out. The fourth question, sorry, the fifth question. So military coups and governance, Ghanaian perspective. Discuss the impact of the various coups in Ghana on this governance and constitutional development. How military regime saved Ghana's current constitutional dispensation under the 1992 constitution. It says that students should refer to the specific cases and legal proclamations such as the National Liberation Council, the Provisional National Defense Council, the laws. Please do Carissa, please do you have any of the do you have any of them? You
No,
don't?
please. This
So how
one
do we
wasn't
do it?
shared with us. I know.
Mr. Samuel, please, do you have any of them? Or do you have any idea?
Not. I'm in fact driving on a highway, so
Oh, okay.
I'm just a bit distracted. What is the question again?
So they're asking, we should discuss the impact of the various coups in Ghana. Yeah. If you're driving, then don't worry. It's fine. You have to. Yeah. So sorry about
Okay, all right. Thank you.
it. Since I don't have access to that material, I'm sorry, but we may have to move on to the next question. Are these tutorial questions that may actually come in your exam? Because I feel like there are questions that are actually trying. They are not. I don't know how to say it. They are not examinable. That's what I feel like. And then let's go on. So failure of democracy is a lesson for the future. Why the past democratic regimes in Ghana failed? And what lessons can be drawn to prevent future failures? So the reason for the past for the failure of democracies in the past, we actually attributed to factors such as political instability, economic challenges, and the lack of accountability. In the sense that leaders that we even elected to power feel like they're not accountable to us. But here lies a case where it sends them there to actually put our best interests at heart and actually in their line of decision making and the deals they make. They actually put the people of Ghana and everything in mind when they are doing that. But I don't think that was the case in the past. In the sense that people actually went there to actually enrich themselves. And then it's like they come to us and the guys are, oh, we want to do this and this for you. And then when they get there, they do what they want to do and forget that they are there because of the people of Ghana. To that's take out the lack of accountability, political instability, and the economic challenges. I think Ghana has actually had a major problem with economics in the past, and I think it's still prevalent in the sense that our funds are mismanaged. There's a lot of corruption in the system. So I think those were actually the key problems that led to the failure of democracies in the past. So then moving on to what can actually be done to prevent it. So I think if corruption is actually to be kept, and then leaders are actually accountable to us, the Ghanaians, in the sense that they are justifying whatever money they are spending, or we can see our value for money in terms of infrastructure and then our basic needs. But as we speak, I don't think we have some basic needs in Ghana. Children are still studying under the tree. Some have to cross rivers, some have to walk long distance. So if you are seeing our value for money actually being done in Ghana, I think it will prevent any future. But I think recently it's come in the news that I think the Mark Palm case, where a doctor was actually trying to plant a coup, but it failed. Very big vote. And then to actually prevent, so you see, maybe there are reasons for actually trying to plan a coup is um, political instability or maybe the fact of the economic challenge, which like we are actually really facing in this time. So we are supposed to also discuss the transition from military rule to the democratic governance, focusing the impact of indemnity provisions and the lack of accountability during military rule. So you realize that during military rule, it's what the military leaders actually see that actually final, right? Because if you look at the Salifa case like this, there was no provision in the decree that actually stated that the boy can't be arrested again. And they are saying that by virtue of the fact that it is not there in public, does not mean it cannot be a law that can be operated. How can you tell me that? But if the courts have given this thing for an order for the boy to be released and be arrested right there, it's to show you that whatever a military leader says is what is actually final. We can't do anything about it. I think it's very good. So discussing the transition from military, I think this is actually really focusing on Jerry John Wallace in the sense that it is in the 19th Constitution that actually provides an indemnity clause to offer protection to any military leader and prevents them from being prosecuted for their actions or being accountable for their actions during their previous tenures. I don't know what the famous of the Constitution were trying to do there, but yeah. Moving on to question 7. What happens when those in power blatantly contravene the Constitution? That the Constitution loses relevance, or is there a way to reconcile such violations within legal theory? I think what happens when people contravene is because I think the Constitution actually continues to lose its value. They say that those in authority actually contravene it about. Let's look at this recent thing in the news where it says that so let's look at this recent this thing in the news where it's talking about how the courts actually what's the name overriding Bagby's Speaker Bagby's what's the name rule in Parliament where he says that he's declaring the NDC as the majority and the APP in the minority in the sense that in 3 or 4 members have tried to cross the carpet. And if you look at Article 97, it says that at the time of your election, if someone tries to change their political party during their tenure in office or at the time of the election, if you're elected as an MPP member, you try to cross carpet to an independent, your seat is actually therefore declared vacant. And you realize that before Speaker Bagby, the previous speaker, was it Professor Michael, actually declared the former MP's seats vacant where he decided to run as an independent candidate. So are we trying to disregard the doctrine of precedence here? No, because if they continue to do this, it means that the Constitution is actually losing its value. And then I don't know. The relevance of it actually is continually diminishes, and it's not a good thing for a democratic country because the Constitution is the supreme law of the land. That one is actually made away because it's Article 1:1. Constitution is actually the supreme law of the land and it has to be regarded. So if our leaders are not actually considering this rule of law, and it actually diminishes the importance and the listening of the Constitution. And you realize that in this past 4 years, you realize the court is always trying to declare an act of parliament null and void. And then we should also realize that the parliament is actually a master of its own proceedings. Yeah. So moving away from that, let's move on to the last question for the day. consider Phillips' theories of revolutions and continuity of law and how they might apply to situations where constitutional framers do not anticipate a coup. Please give me a second. So let's look at it in the sense that John Finnes's perspective on law suggests that a continuity of law may exist even in revolutionary contexts. So, in the sense that constitutional framers actually do not anticipate it, the existing legal order, would I say, may adapt to the new realities whilst they are still drawing from its foundational principles. So the framework will actually provide a structured approach in this. So yeah, so in the principle of continuity, realize that the laws may actually, so from Phillips' theory, it can be drawn that the laws may actually adapt. So it's not in the sense that where Kelson is also saying that if there's a coup d'etat or if there's a coup d'etat, the previous law is actually abolished. So in the sense of the inverted pyramid, it is cut off. And for Phillips, it's not saying that. It's saying that it's going to be made. And if the females are supposed to adapt to it, they will try and adapt to the current situation on the ground and not actually abolish the whole thing. I don't know if you get it. And that being said, I'm actually done for the day. And if you have any questions, please ask. Please, Naki. Naki.
Selassie, are you done?
Yes, dear, I'm done.
All right.
Yeah,
Thank you so much, Selassie.
Yeah, so I told them that I'll send you a material, PKOs with.
Okay.
Let's see, and if I find how Joy is going to, I'll send that as well.
Peter's notes.
Yeah, Peter.
Did you say Peter's notes?
Yeah, do you have Peter's notes already?
It's in a group. Oh.
It's in a group. Oh, then they should
yes,
check.
In a group. They can check the community group.
Yeah, my phone is spoiled, so I don't have access to it.
Okay, so it's when you go to the community group, you can just tap on the search icon and key in constitutional law.pkao. Those are the notes. So you can access everything from there.
I think the tutorial questions were really like questions that I think would be examinable. Like, do you understand?
Yeah.
I think it's just to test the understanding. So, hey, and the paper is tomorrow, right?
Yeah, the paper is tomorrow.
So I'll try and find our past questions for the midterm and send it. But it was primarily, okay, so let me see this. It was primarily true or false.
Mm-hmm.
No, there was an objective paper.
No, fill in the gaps.
Yeah, fill in the gaps. And then you were asked to write functions of the Constitution. I think you have to touch on your classifications of your Constitution. And then classification and types of Constitution. And then, yeah, you should really read the broad definition and the narrow definitions of the Constitution because
I was just about to say that. KCWS definitions of what a constitution is.
Yeah, and then if I remember correctly, he also asked what a constitution was, and he was also asking about a question around the legal sanctity of a constitution. And then the 2-4 versus Attorney General, Justice Sowe's submission about how a constitution is a living organism capable of growth and subject to all these things. Please take that text very serious. Yeah. Please,
so if you have the past questions, you can use the notes I'm talking about to answer.
Yeah. So I'll see you guys some other time and all the best in your papers. Do not hesitate to text me or call me if you need my help. Or you can also talk to Naki. She can talk to me too. So I'll see you guys and all the best. And please,
thank you so much.
Thank you.
Yeah,
Yeah.
in answering non-accurate questions, please always try and go straight to the point. If you are able to get the legal principle, it's actually really, really perfect. Yeah, and then your constitutional provisions, you don't necessarily have to write what exactly the constitution said. You can paraphrase it, but it has to have the meaning of what the constitution was trying to tell us.
And please, if you know you won't be able to remember what exactly is in the constitution, please avoid using quotation marks. Just go straight to the point, because once you put in quotation marks, it means you are going to quote. So please don't avoid using quotation marks if you know you won't be able to remember everything verbatim.
And please do not panic, okay? Please do not panic. You'll be fine. Yeah, actually do not panic. You'll actually be fine. Don't worry. Yeah, so we are around if you need any help at all.
Thank you.
Thank
So
you so
you'll be fine. Bye bye.
Selassie, bye bye.
Bye.